Hi, my name is Emily Leach. I am a privacy director at Blueprint Technologies, and we are here today to celebrate Data Privacy Day. So I am on the call here with three of my colleagues. We have Pari Sarnaut, who is the Director of Privacy Consulting. We have Kevin Donahue, who is our Director of Privacy Engineering, and Molly Hulefeld, who is our privacy consultant, one of our privacy consultants. Um, Blueprint acquired Ethos Privacy a few months back to expand its offerings, our offerings to include privacy services and our privacy technology platform Ethos. So in an effort to advance our privacy chops here, we are going to host this roundtable uh, in celebration of Data Privacy Day. So, what we'll do here today is dig into some of the major challenges that companies are tackling based on some of the things that have happened in the privacy landscape recently. Most notably, we'll start with the laws that are coming into effect in the United States. So, let's go to Molly first. Can you tell us a bit about the laws that we are seeing in the US, where they are, and maybe a little outline on what we think we can expect going forward?
Yeah, sure. So this year we have four pieces of state privacy taking effect right off the bat. January 1st marked California's CPRA and Virginia taking effect. Next up, we have Colorado and Connecticut July 1st, and then Utah will come into place December 31st. And each year we see state lawmakers moving bills further along with the 2023 legislative calendar already happening. We have 8 states proposing comprehensive privacy legislation. Another 4 are introducing children's privacy, similar to the California Age Appropriate Design Code. And then 2 more proposing similar legislation to Illinois' Biometric Information Privacy Act. So it's worth noting that these are not the bills that we saw in 2021 when the real onslaught of privacy legislation happened. 2021 marked New York introducing 50 privacy bills just on their own. So now these bills that we see are, they're really positioned to pass through chambers. 2022, we had about 30 bills coming in, and 15 or 14 of those moved through one chamber, or moved out of committee. So these bills are moving along. And the good news is that we've seen a lot of commonalities for what makes a successful privacy bill. They're not too far reaching. They offer basic data subject rights, and they have no private right of action. And then on a federal level, it's certainly worth noting that the success of the American Data Privacy and Protection Act, it's the first real viable comprehensive privacy bill to appear. And while it did die a slow death due to the issue of preemption, it's anyone's guess as to whether this new Congress will pick it up. There's a lot of speculation at this point.
So we've seen companies get their practices in line with the existing laws and the ones that we know are coming down the pike here. But obviously, we could see a lot more change going forward in terms of the legal landscape for businesses, even those businesses that are just operating in the United States, not necessarily multinationals. So, Pari, if you could chime in on here and talk a little bit about ways that you think companies can be successful in not just preparing for the laws that we know about, but kind of setting themselves up for success going forward?
I think one of the core, or I would say one of the focus areas is like not being ready for right now what's coming up. And as you said, Emily, what would be coming up in next few years? I think post GDPR and post CCPA, now we have learned that privacy is here to stay. And with all these new US state privacy laws, there is a need for organizations and privacy programs to take a flexible and scalable approach when it comes to solution building, right? Whether those are your opt-ins and opt-outs or anything else. So again, we don't want to reinvent the wheel again and again, or we don't want to create solutions for different laws. Right now, I see privacy teams working very closely with engineering teams on building these adaptable solutions so that we can get the best value from the investment made and also provide that consistent and a great experience to the customers as well that helps with the trust building piece. So that's one of the areas where I see a lot of focus, and I'm glad that organizations are moving towards maturing their privacy programs and also the processes and the procedures and the automation to be self-sufficient for now and for future.
That is a fabulous segue to talk to Kevin. As far as the privacy engineering aspect of all of this goes, what are you seeing? What kind of systems are and tools are people putting in place that are helping them deal with this? And can you provide any tips for people out there?
Sure, thanks. I would agree with everything Molly and Pari said so far. The fact is, if you've done GDPR and CCPA, you're pretty well positioned to comply with any new privacy law. Like conceptually, they're all pretty similar, but they tend to have these localization parameters. We like to refer to them as. The most obvious one is definitions of PI, personal information, the time you have to reply to data subject right requests, that kind of thing. And as we see when we work with clients, to Pari's point, you want to invest smartly so that if we're deploying a data subject rights, a DSAR solution, for instance, one way you can build that for the future is to think about how to parameterize some of these things about the response time, the data that's included, where you want to go to kind of gather the data or, delete data or rectify data or something. So, we see in the privacy, when we deploy privacy tools, we see a lot of clients saying, first I did GDPR, then CCPA came, now it's CPRA, now these state laws are coming. Am I going to have to, spend several months every time a new law passes? And, if you don't plan well, yes, you will have to spend those several months every time a new law passes. So one of the things we really like to do with clients is try to future-proof it, like Pari said. And so there's a lot of ways you can go about that. A lot of clients go through a lot of effort to try to figure out, am I going to offer these data subject rights just to this particular geographical location? Or does it actually make sense to offer it kind of broadly? Because, as Pari said, again, I'm going to quote Pari a lot here. You want to make your customers and your users happy. And if there's a low cost way for the company to do that, data rectification, it makes sense to keep your users happy, to allow them to rectify data. You might want to roll that out everywhere. Then you don't have to worry about kind of figuring out in your data mapping phase, for instance, is this just in a particular location? So I think with the tooling, we have people that are looking to invest smartly. The other side of it really quickly is building privacy specific infrastructure is also quite popular, particularly with companies that have a lot of regulatory scrutiny, I guess. And so that if you're going to build a data de-identification system, or if you're going to build some sort of system where you're building profiles of people, for instance, we see clients that are partnering with their product teams to do this kind of globally or across their whole organization, trying to consider canonical privacy and security concepts like data minimization, least privileged access, only retaining data, as long as you've got a reason to keep it. So we see a lot of movement towards this being safer and building more trust.
Great, thank you. So US also, we've seen in the US, there's been some enforcement action, particularly of late. The California AG handed out its first CCPA action. And then we have a major ruling out of Illinois related to its Biometric Information Privacy Act. So Molly, can you talk a little bit about that, about these enforcement actions and what they mean for companies?
Definitely. So the U.S. really picked up enforcement this year. Like you said, California brought its first enforcement action, and that was worth noting that it happened during the right to cure period. So, and it was listed as a possible enforcement case that the Attorney General's office put forward. So they did do their best to avoid that, but the settlement happened, 1.2 million went out for illegally selling data in violation of CCPA. So that's definitely of note. And that cure period ended January 1st. So we'll mark 2023 going forward. But we also saw other landmark cases come out just in the last quarter of 2022, really. We had a coalition of 40 state attorneys generals who announced the largest AG-led consumer privacy settlement. They fined Google $391.5 million over its location tracking practices. So, that's great to see attorneys generals really coming together to pursue privacy cases. We also saw the FTC issue its largest fine to date against a gaming company, Epic, $520 million in two separate settlements, one for violating COPPA and another for using dark patterns to compel players to make in-game purchases. So that represents two separate settlements. But then the big case was that Illinois had its first jury verdict for BIPA, the Biometric Information Privacy Act. And this lawsuit started back in 2019 by a truck driver who alleged that he was required to scan his fingerprint to confirm his identity across the company's facilities. And he alleged that the company failed to disclose the purpose of collecting the fingerprints and that they failed to publish a data retention or destruction policy as required. And the company argued that it was not, in fact, the proper defendant, that, in fact, its vendor who installed the fingerprint scanning and maintained the automated entry and exit should be pursued instead. Now, the real interesting piece here, I think, is that the trial lasted 5 days and was reported that the jury deliberated for an hour. So this was a very quick jury trial. And they awarded the maximum penalty for each violation, a $5,000 penalty issued once for each of the 45,600 truck drivers that it impacted. So BIPA is the most formidable privacy law in the country, thanks to its private right of action. And this verdict should really send a clear message for companies to get their data processing in order and review the vendor agreements.
Yeah, I think that is a really important takeaway from this. It really sheds light on the importance of vendor management for sure. We've also seen that importance highlighted in the wake of the Schrems cases, cross-border data transfer, particularly this last Schrems case where every contract really needed to be unearthed and investigated. So let's dig into vendor management a bit. Kevin, where are you seeing some of the major challenges, and can you offer some tips to organizations to get on the right track with that?
Yeah, vendor management is always fun. I think the main difficulty that we tend to see on engagements is it's hard to identify current vendor agreements. They often there's not really kind of a central location that's up to date and complete. So you have to figure out who's responsible for identifying the people who may know where their contracts are. Okay, that's kind of an internal process. Have those people, are those people still in the company? Have they left the company? Is it a mailing list versus an individual? So just the very project management focused task of identifying where our vendor contracts are is extremely difficult, let alone, targeting one in particular. So, you kind of start with that. And then the other side of it is, how do we get these updated? Who are the people signing on the counterparties? How do you contact them? What's the negotiation process look like? Why would they sign like an updated data protection agreement or something? I mean, we know why conceptually, it's a privacy obligation, but is that are they going to kind of dedicate efforts to negotiating this contract again, to reading it, to redlining it? So, I think the contract management, the biggest challenge is really kind of a project management challenge. And I know Pari's done a lot of this as well, so she probably has a perspective as well. What do you think, Pari?
Yeah, I think a couple of other challenges which I have seen is specific to inventory of these contracts, right? While working with multiple clients over years, I think one thing common was many of these contracts, as we tried to dig into those, seemed like they were outdated, they were hard to find it in the system. These legacy systems, and I call these legacies because, again, these were set a few years back. Nobody cared about privacy 20, 30 years back, right? So we didn't have, or organization didn't have a clear way of filtering or being able to access the contracts they care about. There wasn't a lot of focus on making sure that your contract terms are renewed or are tested on a yearly basis. It's not that you'll sign a contract one time, it's there forever, right? You need to make sure that it's still valid. The vendor is still doing what they are supposed to do as what they state or what the terms and conditions are within the contract. And then really, if something changes, are we updating those contracts, right? There wasn't a focus on doing any kind of audit within the vendors as well. In past few years, we have seen, yes, we do want to audit vendors as well, right? Are they doing what they are saying in the contractual terms? So a lot of issues out there as well. I think with the focus on the privacy, with the obligations GDPR has put, with the Schrems effort, with the CCPA, CPRA terms, right? The way CPRA defines third-party contractor and service providers, it has actually made us think about, let's go back and see what's happening in our contracts. And as we did that exercise, we actually identified a lot of loopholes. I think this is the time for organizations to fix the foundational stuff and really fix whatever their vendor management tool is, set it in a way so that it's the contracts are easy and quick to get hold of. They're easy to update as new laws and obligations come in, saving time for the vendors as well as their teams. So I think there's a lot of focus. People see a lot of value. Organizations are working on that. But I think more than legal aspect, I think it's the foundational stuff that requires some fixing. And I definitely see a lot of focus by organization in that area.
Yeah, I agree. I think this is definitely a time where a lot of organizations are really looking at their kind of historical efforts in this area and doing a pretty decent overhaul, which, you know, brings us to the fact that privacy pros have an awful lot to tackle these days. And generally, the challenges are outweighing the team and the budget to manage them in a lot of cases. So, you know, we've seen a lot of new tools pop up, automations, and I'm wondering if you all have tips for people as far as, you know, how you find the right tool, how you implement tools, what kinds of things you've seen be helpful to managing that workload. Kevin, you want to start with that one?
Sure. Yeah, I mean, tools are fantastic, right? There are a lot of privacy vendors that have a lot of very useful tools. The problem is when you know, we sometimes see clients say, I'm going to deploy a privacy vendor because I have to do privacy and they do privacy. It's kind of like that. And it's like, okay, well, step back a little bit and you want to identify specifically what problems you're trying to solve and how do you evaluate potential solutions? How do you know this vendor that you're trying to deploy actually is going to work for you? You know, tools are meant to be as broadly adopted as possible. And so there's always a lot of nuance when it comes to deploying them. So one of the main things that I see when I work with clients to deploy privacy tooling is to really spend a lot more time than they expect on identifying the problem, defining success, defining done, and then evaluation criteria for the tool, because the tool might be really fantastic in some areas, but it might not be really targeted to what you want to do. It might be difficult to implement. It might be way too comprehensive. It might be very expensive for the use you're going to put it to. And so I think the big value we add with clients tends to be, here are some actual somewhat objective criteria for evaluating tool options. And then the deploying, you know, it's always difficult, but at least if you've had some criteria for evaluating, some sophisticated criteria, you're more likely to realize some value from your investment instead of spending, you know, the next probably couple of years banging your head against that wall, not really seeing why it was worth it.
Yeah.
I-
Go ahead, Pari.
I think, Emily, I have also seen some of our clients, and in my experience, where the organizations identified the problem, and they said, we need to automate this, or we need to get a tool in place. However, when they got the tool in place, first of all, as Kevin mentioned, it took forever for implementation. And when you look at the value the tool got, it was close to nothing for them because it wasn't implemented properly. It took a lot of time. It's not only the cost of the module or tool you buy, it's also the time the team spends on the tool to make it work. And then are we just replicating one tool with another one because it's the big new thing in the in the market? Or is it helping you with something? So really defining the successful criteria for the implementation. I think the other things which is one other area which is often missed is many times it would not be only the privacy teams working within the tools. It would be the other teams as well within your organization who would need to interact with these tools. So getting there, thinking about their user experience is also important, right? And if you can simplify this as much as you can, I think that's the best, right? We want to make sure like it's making our process efficient. It's helping with the speed, right? It's helping us with managing the workload. So really thinking about, okay, before we say, yes, we want this tool, we have certain criteria, we vet them. We test them not only from privacy perspective, but also other users who will be using that. And then how would you scale and mature the tool? Don't expect that first day you'll get the tool and turn on all the functionalities. Think about it as a sequential process where you think, okay, this is my current process. I think I'm okay with it. Can the tool do this? But I want to add these things additionally. But in 3 years, this is where I want to be, right? So you want to make sure that tool allows for your process to mature. You have a journey in place. You have done the testing before you roll out. And then how will you communicate on your strategy, right? If you change one tool to the other and you haven't communicated it outside your privacy team, people who would use it, right? You will have to create manuals, that new process. There's a change management aspect also involved when it comes to tooling. So really thinking beyond just tech and tool, and really thinking about where does it fit in the organization, how it helps with the integration, value it brings not only to you, but others. You can also have opportunities to provide value to other processes and teams beyond privacy team itself. So I think thinking about all those things are also important for any team to successfully use it and actually maximize the return on investment.
Yeah, I think that's a really important point you made about other teams using these tools and making sure that they work throughout your entire organization. I agree with you that it's something that is undervalued, understanding that aspect of it. And also, if you get buy-in from these other teams, it can help, with getting the budget and the more advocates you have for a specific tool or service that will help you out, the better off you're going to be in implementing it, which kind of brings us back around, as I feel like we always end up at, is that privacy is really about relationship building, right? If you don't have those relationships with all these other teams, then you're not going to understand how, they're going to interact with the tool, and you're not going to get their buy-in. And it certainly makes everything much more challenging. So I think that is all we have for today, unless anyone else has something more to add. Thank you, all of you, for taking the time to be part of this with me. And I appreciate your time. For everyone listening out there, thank you so much for being with us today. And keep Blueprint in mind for your privacy needs. Have a great day, everyone, and happy Data Privacy Day.